I want you to think like a lawyer. In order to do that, I'm going to have to teach you a little bit about some specific types of employment contracts. Today, these are Post Employment Restrictive Covenants. They're very interesting. You probably know them by the other names of non-competition, non-solicitation, non-disclosures, and non-disparagement. There are other types of post-employment restrictive covenants, and we'll get to those in a moment. Why are we talking about this? Well, there's some interesting things in the news. One of the things is about two companies that are fighting over non-competitions right now in Cook County in the Chancery Court. I'll let you know for my viewers, I love Cook County's Chancery Court. I used to do a lot of mechanics liens in that location, in that courthouse. Now, mechanics liens, not in the terms of turning wrenches, these are mechanics liens in the construction of buildings, but that's a different story for another day. So who are these companies? Well, one of them is a company called FourKites, who has raised over $200 million. They provide supply chain visibility, basically giving you insights into things you didn't have insights into before, so you can make decisions as to when something's going to arrive and what things you need to do. I'm sure there's more to it, but we'll table that for now. The other company is called Project44. Project44 has raised a little bit more than that, about $800 million, and they offer a substantially similar value proposition of visibility. So, how did we get here? Well, post-employment restrictive covenants are a type of contract that employees sign because an employer asks them to do that. There's a lot of ways you get there, and we're going to get to the question that I want you to think about. The question I want you to think about is, how do I get you to sign a post-employment restrictive covenant? How does an employer convince somebody to give up some of their rights? So let's break down the actual contract of a post-employment restrictive covenant, and then we'll talk about ways you get people to think about them and to sign them. So number one, post-employment restrictive covenants are post-employment. The relationship with that employer is over. That's when the contract actually takes place. It's after you've left. And it's restrictive, so that means that you had something that you gave to your employer. There's a thing that you had, a right to work for anybody that you want to, and you've said, I don't want that right. I'd prefer you, the employer, to tell me who I can and can't work with. And then it's a covenant. It's a contract. It's a thing that you've signed saying, I will be bound by these terms. Now, that is the first part. Like any contract, there has to be an offer, an exchange, and acceptance. You have to say, I agree to these terms. And how do you materialize that intent? We'll get to that later on. So the very nuts and bolts of post-employment restrictive covenants have three primary variables. The first one, how long? How long will I be bound by this document? Is it a month? Is it a year? Is it multiple years? How long am I bound by this post-employment restrictive covenant? Number two that has to be addressed is, how expansive is this? How big is the territory? Is it just my city? Is it my county? Is it my state? Is it the entire country? Is it the world? I have no idea. Those are the variables in geographic scale. The last one, which is probably the one I think is the most important for everybody who's watching this to understand, is, what is the business? What is the business that you do as an employer? You can't tell somebody, for example, we are a painting company and we're not going to allow you to be a carpenter. That doesn't make any sense. You can't do that. It's about the business, the legitimate business interests of the employer. And so when we look at the business interests of the employer, you have to narrowly define, or you can expansively define, what is business? Is the business what I do today? Is the business what I anticipate doing in 6 months? Is the business the things that you worked on as an individual? Or is the business anything that I say that it is? And we're going to be bound by those same limitations. So, backing up, recapping. Post-employment restrictive covenants are a labor contract that you agree to in advance with your employer to limit your own freedom to take the jobs that you want to do. So that's what happened in this FourKites and Project44 case. Two people who have left FourKites have gone to work at Project44. And FourKites is like, no, you don't get to do that. You can't leave me. You can't go and work for them. You signed a contract. Now, when we're talking about contracts, you go to the civil court and then you have the chancery. Chancery is kind of part of civil. It's not criminal, but it's different. Chancery is about equity. Equity is very interesting. What happened in this case is Project 44 opted to protect and litigate on behalf of these new people that they've hired. And FourKites has sued in Chancery Court to make those two people who were hired by Project 44 to be fired. They are saying with this case, if you allow these two people to work for Project 44, it will do irreparable harm. That is a term of art. Irreparable harm. If you want to think about what irreparable harm could mean, imagine if I were to say, and I'll kind of be a little maybe hypothetical, really. If these people go and work for Project 44, my business is done. I am done. I can't compete. These two people, they are my entire business. If you take them, court, chancery judge, please, if you take them away, if you let them work for Project 44, I'm going to go bankrupt. I can't do it. You got to stop them. You got to stop them. And to their credit, Project 44 is saying, that's not true. And most courts are actually kind of like that. Most courts don't like restrictive covenants. They say, for the most part, people should be able to do the jobs they want to do. You shouldn't limit them in these ways. This is kind of unfair. I'll give you an example. There was a company called Nordstrom Rack. They bought a business called Trunk Club. Trunk Club had these personal designers who would help you understand what outfit looks good on you. Those designers signed non-competition agreements. And when they tried to go work for a competitor, they were sued. And people thought about it. And eventually that non-compete got knocked out. But you have to understand, most people will not litigate non-competes. Most people will go, I'll just wait. I don't have the money to fight somebody in court. I don't want the publicity. I don't want someone to think that I'm unhirable because I violated a contract. I'm just going to grin and bear it. The people that are affected by non-competes, there's a lot of them. In some cases, they're executives, senior level people. That's where most people think about the application of these contracts. Specifically, my experience has been selling a business. You sell a business, you're going to sign a non-competition agreement. They're going to say, hey, we love what you've built. Don't go do it again. And so you sign a document and it binds you for a period of time. These are generally enforceable. That's the thing. Most non-competition agreements are enforceable, even if they're not fair, because the court will come back in many jurisdictions and go, you signed it. Why didn't you read it? Why didn't you argue? Why didn't you negotiate? Why did you just let it happen? Well, most people don't know when they're signing a non-competition agreement. And that's the problem I want you to think about. Non-competition agreements are everywhere. They're all over the place. So how do employers get you to sign them? Well, let's talk about an example that I think is probably the most clear. I'm the hiring manager. You are my candidate. And I say, listen, we love you. We think you would do phenomenal with us. But I got to be clear with you. I got to be honest. There are certain documents you're going to have to sign to work with us. One of those documents is called a Post Employment Restrictive Covenant, a non-competition agreement. We are going to give you access to so much information and you're going to have so much visibility into our core business that if you leave and went to a competitor, it would do enormous damage to us. We are trying to plan what the future is going to look like in the next 5 or 10 years. And if you know what that looks like, we're kind of concerned. And so in order for you to work with us, you're going to have to sign this document. And then you as a candidate can say, well, I really want to work with you. I think that sounds great. Let me go ahead and sign that document. Now, in some circumstances, an employer may say, if you sign this document, we're going to give you an extra bonus. We're going to give you a sign-on bonus for $20,000, $30,000, whatever dollar amount you want, because that is the separate consideration. When you offer someone a job and you make them sign a non-competition agreement, some states will say, you agreed to it, and that job offer is good enough to act as consideration. It's good enough to make this contract enforceable. Some states, Illinois being one of them, if you don't have separate consideration, you better be on the lookout because that contract is probably not going to stand up in court. Anyway, so that way I described it, it doesn't work that way. That's not how we do it. What typically happens is that contract with the non-competition is buried. in something like a non-disclosure agreement. And so the non-disclosure says, hey, you're going to get access to a whole bunch of stuff. We just need to make sure that if you get exposed to this stuff and you go out into the world, you make sure you sign up and say, hey, I'm not going to tell anybody about what I learned. And by the way, on paragraph 8, there's a non-competition agreement. Don't worry about that. We never enforce it. Everyone has to sign it. That's just how we do it. That's how one way you get these non-competition agreements to be executed. Oftentimes, you've already been offered the job and you've accepted it and you're ready to go. And on the onboarding day, you're given a bunch of paperwork. And the paperwork has all these different things that you fill out. One of those things may very well be a non-competition agreement. This is why it's so interesting to figure out, how do you get someone to sign this? So we've talked about a couple different ways. You're upfront and candid and say, I need you to sign this, and otherwise we can't extend the offer. Another way is you surreptitiously hide it in another document and you don't tell the candidate what you're going to get into. That's another thing that's probably something we ought to address. Now, there's other ways you can do it. Severance agreements. Hey, we're done working with you. It's been a pleasure. We're going to move this relationship on. But in the interim, here's some money and a contract telling us that you will not compete with us for a period of time. Again, that's another somewhat typical way, much more easily to enforce. That severance agreement tied with the non-competition gives you that consideration we've been talking about. But that's, again, not always what happens. Think of it this way. When you are an employee, you're in an employment relationship. It's a relationship. And when that relationship breaks down, generally you're at will most of the time. And if you're at will, we can leave for any reason at all. And you can lose your job for any reason other than the protected reasons we would talk about in a future Thinking Like a Lawyer. So when you're in that moment and you're like, okay, what are we signing here? What are we doing? You say, we should see other people, and you're breaking up. But imagine if you were with your partner says, well, we're going to break up and you cannot date anyone else like me for the next year. We're going to mandate you can't do that. So this is what happens with these non-competition agreements. You have ended the relationship, but you gave up some rights. And those rights are these rights to work for the companies you want to work for. Again, I think these contracts are useful. They're very important, but they are abused in ways that we ought not to tolerate, especially in the industry of supply chain. A broker is a great person, very valuable to an organization, but they shouldn't be subject to a non-competition agreement. And I've even seen mechanics sign non-competition agreements with the employer fully well knowing these aren't going to be enforceable, but knowing that a large portion of the people who would sign this document don't know they're not enforceable. So here's the question for you. I need you to get your candidate to sign a non-competition agreement. What's the way that we do it? Well, number one, we can be candid and explain to the candidate what it is that you're going to sign. We could, 2, hide it so the candidate can't see it. Or 3, we can tie it to some end of the relationship severance agreement. These are all some of the ways that you can get someone to sign these documents. This is what Thinking Like a Lawyer is. You have to know foundationally, what is a post-employment restrictive covenant? Fundamentally, it's a contract between an employer and an employee, or a candidate who may become an employee. Secondarily, the laws, they vary state to state. Some laws say that if you sign the contract, you sign the contract. You're bound by what you've signed. But if you're in a state that is a little bit more, let's say, liberal or pro-worker, they might say, you know what? Maybe you should get separate consideration, separate payment. And then you know the ways you can get these people to sign these things. What I urge everyone to do, as I do with every client that I have, and again, this is not legal advice, this is just Matt Leffler giving you some advice when you're out there looking for a new job. Ask about the Post-Employment Restrictive Covenants in the very first conversation. If they like you and you're interviewing, the things you can ask is, look, I love this company. It's fascinating. I'm so interested in what the problem that you're solving. But if you have any documentation I need to sign in order to be an employee, I'd love to have a chance to review that document. In every circumstance, ask for more time to review the documents. If you have a non-competition in front of you, it may or may not be enforceable. You should assume anything that you sign is going to be held completely enforceable against you. Believe it. That's how it works. And even if you don't think it can apply to you, if you litigate it, it's out of your own pocket. Project 44 is doing something phenomenal. They are stepping and helping pay for the litigation costs of these individuals who FourKites is saying, if you do this to me, I will lose my business. It's bullshit. It's ridiculous. It's nonsense. I don't like post-employment restrictive covenants when they're used in ways that abuse the judicial system. This case in Chancery, I might go stop by. It sounds interesting, doesn't it? To be kind of like a reporter stepping inside one of these things, saying, what is this case actually like? What are these lawyers thinking? What is the argument that they're making? For the lawyers that watch these things, watch me talk about different types of legal issues, I urge you to ask your clients about these types of contracts and how they use them. The winds of change are happening. These are not popular agreements. These are very anti-worker, very anti-customer, and ultimately anti-shareholder. The publicity that you get for pushing out these things to people that don't understand them. I mean, at the minimum, if you're an employer who has the ability to force people to sign non-competition agreements, pay for the legal fees for your candidate to evaluate whether they should do this or not. Because we can negotiate all of those things. Just like you do negotiations for rates, right? You negotiate everything. Everything's a negotiation. Maybe the time off that you have is something you can negotiate. Maybe the amount of your daily, what time you have to answer phone calls or emails. How many times you got to do a certain activity. These are all things that you negotiate early on with your compensation package. I have been on a ton of teams over the years that I've worked in all these different industries. Some of my colleagues have non-competitions. Others didn't. Because the ones that didn't said they didn't want to sign them. You don't have to sign those things. You don't have to. But if you do, you better understand what it means. So I'm going to continue to follow the FourKites and Project 44 stuff. It's fascinating. And I'm really excited to watch FourKites lose. They should. They should lose so hard. And I hope that the customers of Project 44 go, that is a really interesting company. I really like what they're doing in terms of helping their employees and their teammates. It's easy to be excited about teammates when they join you. You send a bunch of stuff, they get excited, they post it on social media. I've been guilty of that from time to time. But what happens when the employment relationship showers? What do you do then? Well, you get the lawyers involved in some cases. So that is the end of Thinking Like a Lawyer for today. The first kind of foray into really addressing a specific legal topic, non-competition agreements that are part of a broader category of post-employment restrictive covenants. How they get executed and what matters tends to be around how long they last, how wide they span, and what it really is that you're not allowed to do under that period of time in that geographic area. Courts interpret these things differently in every single state, and that's because employment law is generally state-based. And when you're faced with a non-competition agreement, employers should always be candid with what it is that they're recommending or saying must be executed in order to have that job. As always, continue to follow along. I appreciate everybody's support, and I hope this video is helpful in understanding post-employment restrictive covenants. What are the stakes? Who pays for the litigation? And ultimately, is it something you should do as a business? My answer, probably not. As always, thank you so much.